rise.
Good morning. Please be seated. We're here today in Jarrell versus Defendall. Our case number is CACV 130539. These proceedings are being audio and video recorded, and we would ask that you identify yourself and your client at the start of your argument. Each of you will have 20 minutes, and appellant, you'll be responsible for reserving whatever time you'd like for rebuttal. We have read the briefs and we've conferenced this matter, and with that, we look forward to your argument.
Thank you, Your Honor. Good morning to the panel. My name is Bill Begley. I'm here representing Shane Defendall and his employer at the time of this event, Telcom Construction. With me is Attorney Nelson Mixon as well. We have brought two issues to the court on appeal. The first one involving the trial court's granting of the plaintiff Gerald's motion for new trial. I'm sure the court, in reviewing the briefs, is very familiar with the judge's minute entry. Essentially, the trial court went through and found the jury instructions were proper, found that there was not a need for a judgment as a matter of law on the issue of negligence per se, but under Rule 59A8, what I believe is commonly referred to as the ninth juror standard, the judge made the decision to grant the motion. In terms of this court's standard of appellate review, it is abuse of discretion, but as we point out in our briefs, if the probative force of the evidence, and we submit that the evidence in this matter is substantial, demonstrates that the verdict was correct, the judge is not to exercise that discretion. It would be an abuse. This way, as the cases have told us through time in our state, you maintain the integrity of the jury trial system. Both sides at the very beginning of this matter asked for a trial by jury, not a trial to the bench. And in addition, as the cases state, the judges, trial judges are not free to reweigh the evidence, even if their personal feelings are leading them one way or the other. So our position to the Court of Appeals in requesting reversal of the judge's grant is the fact that there is no basis for that new trial. And we point out in our briefs, as far as the evidence in the record, here we have a situation where the plaintiff is a pedestrian and the defendant is driving a large work truck. But what we had here was a 3-day trial, and the transcripts have been added to the record on appeal. We have testimony from two independent eyewitnesses, Mr. Jacobson and, Mr. Martinez and Mr. Flores, and both of them state, both in their depositions and then at trial, Mr. Flores was able to appear, but Mr. Martinez's depo was read into the record. Both of them state that the plaintiff walked into the side of the truck, which, as we point out in our arguments, puts the truck in front of the plaintiff. The truck was executing a right-hand turn. Plaintiff was proceeding forward. And as the truck driver testified, without any contrary evidence, he was almost 3/4 of the way through his turn. In addition, the plaintiff impacted the rear side portion of the truck, with the primary causative agent of the injury being the rear wheel on the truck. The plaintiff testified that she was only 1 to 1.5 steps into the crosswalk. The driver of the truck explained that he was making his right turn from a stop at the intersection, that he had checked both ways, that there was no one within the crosswalk at the time he began his turn. And in addition to the testimony, the expert analysis of Dr. Joseph Pellis was offered to this jury as well. And we have provided you with his slide presentation that shows a step-by-step movement of the truck and the pedestrian. And what it comes down to, as I'm sure the court can appreciate, is the truck was already within the particular crosswalk, almost through its turn, and the pedestrian chose to step into the crosswalk. Therefore, it seems obvious why the jury would have reached its result, which was to find in favor of the defendant, and find in favor of the defendant unanimously, 8-0.
Let's say that, I just want to explore the standards of review here. Let's say that everything you said came out at trial and it was all completely incredible. For whatever reason, and I'm not saying this is the case, but for whatever reason, it was obvious to the trial judge that the witnesses were lying. Can the trial judge at that point, even though there is this evidence in the record, can the trial judge exercise his discretion?
Yes, Your Honor. I believe if the trial judge makes a determination into something that is misleading so that there is something to indicate the evidence would be contrary to what has been stated, that being a credibility issue.
Well, but then how does that differ from reweighing the evidence?
Well, in quoting the case of Cal Extra versus WVSV Holdings, the court stated, courts are not free to reweigh the evidence and set aside the jury verdict merely because the jury could have drawn different inferences or conclusions, or because judges feel that other results are more reasonable. And they cite Hutcherson.
I'm positing a different situation to try and explore the parameters of the standard of review, because you're on an abuse of discretion standard, and we have to really know what standard the judge was supposed to operate under, right?
Exactly, Your Honor. And
so if the judge doesn't simply prefer a different result, but came across some piece of evidence that in his mind absolutely undercut, made it impossible for the evidence for one side or the other to be true, the judge has the ninth juror power at that point to act, yes?
Yes, Your Honor.
And I'm not suggesting that happened here. But if we agree that that's a little bit different from the prohibition on reweighing the evidence,
yes, Your Honor.
Then the next question is, where is the daylight, if any, between the standard for a motion for judgment a matter of law under Rule 50 and exercising discretion under the ninth juror doctrine?
Well, without wanting to be repetitive at all, to Your Honor, I would simply turn back to the standard of review cases cited. And as far as what went on in this case, the evidence we have, the best evidence we have, is the trial court's minute entry dated May 13, 2013. And I would submit to the court that if you read through the judge, after you block off everything where he denies the chance that this case should be retried, all that's left is him suggesting that there seems to be some confusion to him, that in regard to the matter, there was a suggestion of a blind spot, which we have argued in our briefs was really a red herring in this case, and that he was confused by matters such as the plaintiff claims she never saw this large white diesel work truck before she stepped into the side of it.
I understand, and that's important material in the record, but as a matter of law, when we talk about the legal standard, is the test for whether the judge can exercise discretion to order a new trial essentially the same as that under Rule 50? In other words, the judge would have to conclude that no reasonable jury could ever find in favor of whichever side it found in favor of?
With an analysis of the evidence necessary to rise to the level, I would agree with Your Honor that they're not just looking for what I was suggesting would be an infallibility standard as opposed to the ninth juror. They are suggesting that if the judge spots something that is there's something wrong going on in the trial of the matter, the submission of it to the jury deliberating, the jury giving a result, he has the power to step in and order a new trial. So I do think there is a similarity, Your Honor, between the two rules.
Could I ask you real briefly about the jury instruction?
Yes.
I don't have any kind of problem with the second part of the instruction that says a pedestrian has an obligation to use reasonable care under the circumstances. But the first sentence before that part of the instruction says that the pedestrian has an obligation to look for approaching vehicles. Are you suggesting a pedestrian has the responsibility to look back in situations like this where someone's turning right? Is a pedestrian obligated to turn their head backwards and look and see, isn't that the approaching traffic coming from behind?
Well, Your Honor, I would note the presentation of what I think are at least three jury instructions. In the middle, we have the two statutes, one dealing with crosswalk, one dealing with walk signal. At the end, we have the two sentences that Your Honor is discussing. But right before that, you have the assume laws obeyed, duty to observe jury instruction, a standard Raji that was also read to the jury, saying that all pedestrians and drivers have a continuing duty to make that degree of observation that a reasonably careful person would make under similar circumstances.
Isn't that covered by the second sentence that you need to exercise reasonable care? Why say you also have to look for approaching vehicles if they're coming from behind?
Well, I think, Your Honor, first of all, of course, in this case, the vehicle's in front of her. At the time, she should have observed it, not behind. And secondly, I think what it is, Your Honor, and this was in trying to understand all of the text of this matter and what troubled the judge, I think what the judge was fighting very hard to avoid, as he discussed in the transcript on finalizing jury instructions, was the idea that the crosswalk or that walk signal becomes some magic protective zone that at any time the plaintiff can step right in and all bets are off for anyone who hits the plaintiff. Obviously, I think what the judge wanted the jury to understand, and he did a very good job of it, was that there are responsibilities and duties both ways. And under the facts of this case, that jury instruction makes perfect sense because, again, the truck is in front of her. Without trying to shorten the argument on that issue, which we believe is really the issue that we've asked the court to assist us with today, the granting of the new trial, we do have raised a secondary issue. As we point out, if the court agrees and reverses, this secondary issue is of no consequence. But a motion in limine regarding the accident reconstructionist that plaintiff provided was also denied. And we believe under the 702 standards of who is an expert witness and what is their job and how do they help the jury, that in all the testimony at deposition that we quoted of Mr. Botsko, the reconstructionist, he was bringing absolutely nothing to this table except to say, he's not right. Dr. Pellis isn't right. The one time he comes up with a number, the acceleration rate of 0.15 Gs as opposed to Dr. Pellis's 0.1. On cross-examination, he admits that he's not considering a truck turning as opposed to a passenger car going straight forward, in which a faster acceleration would be appropriate. But we think that if you read through his deposition testimony, all he brought to this trial was confusion. And it seems like the court, as a gatekeeper under 702, is to prevent that from happening. So if this court ends up deciding that there should be a retrial of this case, we would ask that you give direction to the trial court to exclude the testimony of the plaintiff's accident reconstructionist. Also, in addition to the testimony, we would urge the court to examine Dr. Pellis's testimony as well, and the slide presentation. One of the points Mr. Botsko kept bringing up is there's no physical evidence to create any numbers in this case. We've provided the court with the scene photos that were taken. Unfortunately, the very efficient city was already cleaning up the street, as you will see suds in some of the photos, but you can see the red-pink debris of the injury area for where the plaintiff's foot was caught with the wheel. It is very close to the curb, just barely entering the crosswalk. Again, in terms of overcoming an abuse of discretion standard, which we completely understand it's not de novo, and so we have quite a hill to climb. It just seems that when you read through the judge's minute entry and you note all of the matters that he says were properly done, jury instructions, conduct of the trial, you have a 3-day trial with a lot of witnesses, a lot of exhibits. You have a jury deliberating for about an hour and a half, and you have a unanimous verdict in favor of the defendant. And as we know from the preliminary jury instructions, sympathy is not the jury's job. It's to determine the facts. So in that regard, what we would ask the court for is to reverse the granting of the motion for new trial and remand the matter with instructions for the court to reinstitute the judgment that was entered by the jury. And I would like to reserve my remaining time for rebuttal, if I may.
Thank you.
May it please the court, my name is John Gustafson, and along with Cole Sorensen, we represent Marcia Gerald, who is present in the courtroom. I would like to address the negligence per se issue, which to me is critical, because I think if we resolve that correctly, a lot of these other issues will resolve themselves. One of our issues is the judgment as a matter of law. And as to negligence per se, first we have to figure out the facts, then we have to figure out the applicable law. The standard of review in this case is we got to construe the facts, like most favorable to the other side. So I'm going to spend some time addressing the facts, and then I want to talk about the statutory law that I think is applicable. Basically, Diffenthal, the driver, testified he arrived at the right-hand turn lane just as the light turned red. Marcia testified she arrived at the corner just as the green cycle was finishing, meaning they're showing up at the same time, right about when the yellow light's going. Now, both the driver and the pedestrian then have to wait for an entire red light cycle, which, now Marcia was waiting for the walk signal because she's going to go north. The driver is waiting to make a right-hand turn. He is playing with his GPS, trying to figure out where to go. He's waiting to turn right. He has not noticed that he doesn't need to wait because he could make a right turn on red. Nevertheless, he waits for what he thinks should be a green turn arrow. There is no green turn arrow. As he does that, his GPS continues to play, then eventually the green light comes on and the walk signal comes on. The party stipulated to the timing of the traffic lights. So what's going to happen is when the green light comes on, you're going to get 13.5 seconds of a walk signal and 16 seconds of a flashing don't walk signal. And probably, from the way I read it, they probably stood there and waited for the green light for about 56.5 seconds. So both of them were standing there. Marcia testified she saw the truck and figured the truck saw her. When the light comes on and the walk signal appears, Marcia starts to walk, the driver starts to drive. Then there's a collision in the crosswalk. Now, as to the independent witnesses were behind the truck. Their cars lined up behind the different adult truck. They say they saw, let me represent this with a demo. These fingers are the pedestrian, this hand's the truck. Here's what, from behind, they would see the truck, her walking into the truck. Let's assume the court here are witnesses on the other side of the street. What this court would see, or what the witnesses would see, here comes the person, here comes the truck. In other words, from that perspective, the truck ran into her path. Now, I would like to talk now about what I think are the relevant statutes.
Can I ask you first one question? Do you agree that a pedestrian does have a duty to exercise reasonable care before entering, even when there's a flashing green light, a walk signal?
I think it's different between the flashing green light or the walk signal.
Is there ever a time when we're not under a duty to exercise reasonable care?
No, I don't think so. I think everybody is.
So would the answer to Judge Catani's question then be yes?
Yeah, but I think the walk signal is different than the normal situation. And here's what I mean. The case that they cite, say Thompson from 1958. Mm-hmm. That scenario is a car making a left-hand turn, pedestrian gets in the way. Okay? There's a duty, there's a difference between pedestrian, you know there's traffic coming, stay out of their way. That's different than the walk signal, which what a walk signal does, it stops traffic all over the place.
Well, not really.
Yeah, it does. I mean,
It's supposed to stop most traffic, but there is turning traffic that can
Correct.
turn. And there may be traffic that doesn't stop. There may be traffic that's coming too fast. There may be somebody who's going to run a light. I mean, isn't it a correct statement of law that a pedestrian has a duty to exercise reasonable care?
yes.
I don't know of any situation where the right-of-way relieves one of the obligation to exercise reasonable care.
I would agree with that.
Okay.
If I gave how about a hypothetical might illustrate my point perhaps. Suppose there was a stop sign and there's a crosswalk here and cars approaching the stop sign, pedestrian walking along, pedestrian assumes the car's going to stop. Well, the car doesn't stop, it hits the pedestrian. While the pedestrian had a duty.
In that case, the pedestrian's in the crosswalk lawfully and has the right-of-way,
Right.
but still has a duty to exercise reasonable care.
Correct. But I think that's analogous to this situation where when it says walk, she gets to walk into the crosswalk.
Well, isn't there a difference, though, if someone is walking in the crosswalk and someone from behind turns and hits her from the side? Isn't there a difference between that scenario and a situation where someone is walking into an intersection and and presumably can see an object in front of them.
Right.
Wouldn't reasonable care suggest that there's a difference there, that maybe you shouldn't step forward as opposed to maybe there's a different result if you didn't see a car coming from behind you?
Right, I would agree with that.
But if that's the case, then isn't there a basis for what the jury decided? Is there a disagreement about whether the truck was in front of her?
I think it happened so fast. Well, a split second before the impact, yeah. I mean, but it happens, she's only 2 steps into the crosswalk.
Well, I can well understand your client's case, and I can well understand why a jury could have found for her. The question I think that we have to answer is whether the trial judge applied the correct standard in granting a new trial. And the trial judge apparently thought that your client should have won, which is not unreasonable from the record we have. But what rules govern the granting of the motion for a new trial? And I'll ask you the same question I asked your colleague. Is there any difference at all between the standard governing the motion for new trial and the standard under Rule 50?
In my view, the 9th juror standard, the judge can sit back and say, what happened here is simply not just.
The judge can say, I wish the plaintiff would have won, so I'm going to order a new trial. Is that your position?
I think I would wish they would say it quite differently. They'd probably say substantial justice was not done.
But at the end of the day, aren't we expressing the same standard, mine a little more colloquially?
Well, I think the 9th juror standard allows the judge to do that.
But if that's the case, then what's our standard of review? How could we ever then say the trial judge abused his discretion? We weren't there. We didn't see the evidence. Right. If the judge has that broad discretion, then it's essentially unreviewable, isn't it?
Yes. Virtually, yes.
So are you suggesting then that we lack power to review these orders?
No. I'm just saying it's the highest standard there is.
That it's abuse of discretion, you mean?
Well, it's more than abuse of discretion. Did the trial judge act unreasonably and manifestly abuse his discretion? So I see abuse of discretion here, and this is way up here.
Well, what do you do about the case law then that talks about a standard that's very similar to the Rule 50 standard? In other words, the judge can't grant the new trial unless he essentially finds that no reasonable juror jury could have done what this one did. And that is the case law, right?
Could you run that by me again? I'm sorry.
The standard that we were just discussing
Right.
is the standard that says the trial judge really lacks the authority to grant a new trial if he merely disagrees with the jury. Instead, he has to find that the jury's verdict was essentially impossible for a reasonable jury to issue. I'd be happy to pull up the case.
No, I'm
that's
I'm just trying to understand.
that's a standard that I think we have to reckon with, because it looks to me like the trial judge, in addition to feeling strongly that the plaintiff should have won in this case, also felt that it was a really tough decision. And if it's a really tough decision, isn't that where the jury reigns supreme?
I don't read the judge's decision, the minute entry here, as thinking it was a really tough decision.
Didn't he say exactly that?
Well, it's the comparative fault part. What he actually said, he's agreeing that Diffendahl was negligent. In fact, he ultimately says, the court acknowledges it was somewhat surprised at the verdict and considered it unfair to the plaintiff. And then at another point he says, apparently the jury did not allocate the relative degrees of fault because it did not make a determination that defendant was negligent.
But did it have to? I mean, if a determination that the defendant was negligent was necessary on this record, wouldn't the court have granted the Rule 50 motion?
In Rule 50s, which, I'm sorry.
The motion for judgment as a matter
Right.
of law?
I think The judge should have granted the Rule 50.
But he didn't.
Correct.
So the question is, was he applying the right standard when he granted the new trial?
I think his minute entry explores that. I mean, it demonstrates that. And the motion for the post-trial motion specifically directed him to the relevant case law, which at the time was the Walsh case, the recent case from the Arizona Supreme Court. So I'm of the opinion that he should have granted the judgment as a matter of law. But if I may, can I get back? I would like to address the negligence per se.
Can I ask you a question?
Sure.
Before you do? And it has to do with this concept of the ninth juror and granting a new trial really on the basis of what sounds like the sufficiency of the evidence as opposed to a procedural irregularity or an issue concerning witness qualification. And Mr. Begley made the point, and I don't know, I'm interested in your take on this, and that is the fact that the jury here unanimously concluded the defendant was not negligent. And so if the judge has a different view of that, does that really matter? Is that really a basis to set aside, to grant a new trial, if the judge simply viewed the sufficiency of the evidence differently than 8 other people?
I think as a ninth juror, he can disagree with him.
But if he can do that, then doesn't that mean he's just choosing the result? Because he can grant a new trial until they find a jury that'll come back the way he wants. And that doesn't seem, that's certainly not clear from the rules.
No. In essence, the way I see it, at least my background was generally criminal. We used to call it the 13th juror standard. And essentially, the judge could, in essence, hang the jury. But that doesn't mean he's going to do it forever. In other words...
Well, the judge can find under the 13th juror doctrine that the verdict shocks the conscience. Essentially, under the 13th juror doctrine, the judge can't force a conviction,
Right.
but can prevent a conviction if he is convinced that the defendant is innocent, for example.
Correct.
But that's very different from the civil rule governing motions for new trial.
Right.
Wouldn't you agree?
Well, yes.
Okay.
Getting back to the negligence per se, in my view, see, the problem was the jury instructions. That what was relevant was the critical language was the statutory language, the 26 words of the walk signal statute, which reads, and I'll read them to you, pedestrians facing the signal, walk signal, may proceed across the roadway in the direction of the signal and shall be given the right of way by the drivers of vehicles. That to me is pretty clear. You can juxtapose it with the statute before, which tells pedestrians not to enter the roadway when there is a red light. So there's a statute that says pedestrian don't go in the roadway if there's a red light. And there's a statute that says walk into the roadway when there's a walk signal. That, to me, is clear. That's what the statute is. What the other side did was impose a duty on the pedestrian to look out for the truck.
You agreed that there is a duty of reasonable care.
Yes.
So why is it improper to
Here's
instruct the jurors on that?
Because here's what happens. This is the truck. This is the pedestrian, right? Truck has a duty under the statute to yield to the pedestrian. Under their version, the pedestrian, once they start moving, the pedestrian has a duty to yield to the truck. So we got two competing duties to yield, two right-of-ways created. If she starts walking, he starts moving. They're frozen in time.
Well,
There needs to be...
I think the question, at least in this evidence, was where was your client at the time the truck was moving? And this kind of goes back to your your statement earlier saying we have to look at the evidence in light most favorable.
Right.
And as I understand that evidence, the truck was moving, and the plaintiff walked into it. I'm sure that's not the way she felt about it, but there was no, these witnesses testified she walked into the truck. There were no independent witnesses,
Right.
as I understand it, from across the street to support the hypothetical you were showing us with your
Yeah.
hands. So I'm trying to understand here what the factual basis is. You're saying there's no factual basis to support the instruction here, and I'm,
Well, I guess what I'm saying is that the pedestrian on the sidewalk has the right to then walk into the street. In other words, there's a duty on the driver to find the pedestrian, okay? So the driver,
You would agree, for example, if a car is making a right turn and the pedestrian is 5 feet away from the corner, the pedestrian can't just run into the car
Right.
in front of it. And I guess that's the whole point of just exercising reasonable care, is all that instruction seems to be suggesting to me. The pedestrian has to exercise, and I'm not suggesting she ran,
Right.
but the point is it's not just negligence per se, just because you happen to hit someone. If the pedestrian did not exercise reasonable care, then there may not be liability. Is that not accurate?
well, on the facts of this case, even if we assume their expert is correct, she was supposedly standing in his blind spot. I mean, she's standing where people are expected to wait for the walk signal. So he had a duty to see her, in my view anyway. So when the walk signal comes on, he should find her.
But isn't that what the jury was tasked with deciding, was whether he was negligent, whether she was negligent? It seems to me there's evidence from which a jury could conclude that the driver was not negligent.
I can't see that. I don't see it. Sorry. I think, I simply can't see it. That he had to have been negligent. And I see my time has run out.
Yeah, and I neglected to note that there is a cross appeal. If you want to address the cross appeal issue following the rebuttal, you're welcome to have another minute to do that.
Thank you, Your Honor.
I would submit to the panel that the cross appeal, which is that the jury instructions were faulty or that there should have been a judgment as a matter of law and negligence per se, is absolutely intertwined with what we're arguing as to why the trial court should be reversed on granting a new trial. And I think you'll see the similarity in the arguments from your review of the briefs. I wanted to come back to something Judge Swan had asked about with regard to the ninth juror, the standard of appellate review. In our brief, we quoted the Hutcherson case, and we took the following language out of that case. In ruling for a motion for new trial, the judge sits as the ninth juror in a civil case. And then they go on and say, the basic question he or she must ask is whether the jury verdict is so manifestly unfair, unreasonable, and outrageous as to shock the conscience. And I heard Judge Swan use the shock the conscience comparison in a criminal case. Here we have Hutcherson saying that's the standard for the trial judge to make this call. And I would suggest that what you read in the minute entry is well below a shock the conscience. In fact, and my colleague quoted some of the minute entry, but I'd like to quote the entire couple of sentences here right before the judge grants the motion for new trial. The court is required to reconcile its own surprise and sense of fairness. I didn't come across that kind of language in any of the standard of review cases I looked at. As noted on the record, the court believed that the jury would ultimately have to determine the relative degrees of fault between plaintiff and defendant. Notice relative degrees of fault, something they did not do. Apparently, the jury did not allocate the relative degrees of fault because it did not make a determination that defendant was negligent. I believe what caught the trial court by surprise is that this was not going to be a 0/100% case. It was going to be whatever number we could hypothetically pick, 1/99. That certainly is not grounds to call for a new trial. 8 jurors heard this for 3 days, received all the evidence. We know Arizona has very strong constitutional protections on the right to trial by jury. The sufficiency of the evidence, we continue to suggest, is just overwhelming as to how you could find that the defendant was not negligent. He's not to be punished under the law for being the one who has a vehicle as opposed to being a pedestrian. There are reasonable care duties on both sides, as even the adversary has acknowledged today. And then you have all of the evidence, both testimonial, Dr. Pellis's expert analysis, and the physical evidence in terms of the blood and debris on the road. I believe that's all I have in terms of our request for the court to reverse on the motion, on the grant of the motion for new trial, and to ask the trial court to reinstate the judgment, as well as to, if you continue to allow a retrial of this matter, to exclude the accident reconstructionist, unless the court has any questions.
Thank you.
Thank you.
Put 1 minute on.
Thank you, Your Honor. I will make it very brief. I think we're almost starting to agree on something here. What I mean is, the judgment as a matter of law is rarely granted. And in this case, the judge granted the motion for a new trial because comparative fault was not applied.
How does the judge know that? Comparative fault could have been applied, and the jury determined that the comparison is 0 and 100.
Well, because the judge determined, I think, as per his minute entry, that obviously the driver was negligent. In that he didn't yield.
Didn't feel it was obvious enough that he should grant a motion for judgment as a matter of law. He felt that that should be committed to the jury.
Well, in my view, he should have granted the judgment as a matter of law. But, and I got 3 seconds left, and I'll wrap it up. Thank you, Your Honor.
Thank you, counsel, for your arguments. We'll take this matter under advisement and issue a decision in due course. We do have one more argument today, but we'll take a brief recess before then. Thank you.